Hello, and welcome to Working Wise, a podcast created and produced by K&L Gates. This episode of Working Wise is recorded in collaboration with Triage, a K&L Gates podcast that discusses the latest developments in health law. We hope you enjoyed this episode.
Hello, and welcome to this K&L Gates podcast on updates to healthcare employment laws from 2022. My name is Sarah Carlins. I'm a partner in the K&L Gates healthcare law practice. I'm here today with my colleague Spencer Hamer, who's a partner in our labor, employment, and workplace safety group. Today, Spencer is going to share with us some insight into new laws and guidance that certain states, as well as the federal government, have issued pertaining to workers in the healthcare industry. So, Spencer, to kick it off, I understand that certain federal regulations have been issued regarding telehealth. Can you talk about that?
Yes, that's right, Sarah. For 2022, there were several developments at the federal level. So to start off, the Department of Health and Human Services has issued guidance for telehealth providers in the area of patients with disabilities and limited English proficiency. So various laws apply in this area, including the Rehabilitation Act, the Americans with Disabilities Act, or ADA, Civil Rights Act of 1964, and the Affordable Care Act. And basically, these laws prohibit discrimination in the provision of telehealth services. And we do have existing regulations and guidance that focuses on discrimination in telehealth on the basis of disability, race, color or national origin, sex, age, sexual orientation, gender identity. And similar to the Americans with Disabilities Act, there is an exception if certain actions would result in undue financial and administrative burdens or a fundamental alteration of a health program. Now, it is healthcare providers' failure to take appropriate action to ensure that care provided through telehealth is accessible, and failure to do so can result in a claim of unlawful discrimination. So that's something that healthcare employers need to be very aware of. Now, the U.S. Department of Health and Human Services Office for Civil Rights and the U.S. Department of Justice's Civil Rights Division have promulgated additional guidance in this area that healthcare employers need to take note of. And the guidance explains circumstances in which individuals with disabilities or with limited English proficiency may face barriers when accessing telehealth services. It also provides examples of reasonable modifications that healthcare providers can adopt, such as providing additional support to patients before, during, and after a virtual visit to avoid unequal treatment in providing telehealth services. The joint guidance also demonstrates the federal government's focus on examining complaints of discrimination in telehealth, including by providing links for potentially aggrieved individuals to file complaints against providers. Just to comment, so I would say that it's really important to look at this as a way to conform existing policies or update existing policies for telehealth providers. And also add that while the EEOC guidance is important, it doesn't have the same force of law as a court ruling, but nevertheless, by following it, employers will be in a very good position to say that they've taken appropriate action with their policies and procedures.
Yeah, in this area. And that's important because, so much of the world is telehealth now and will continue to be. So thank you for that. Turning to COVID for a minute, tell us what's been happening with COVID vaccine requirements and COVID testing for healthcare providers. Were there any important changes in 2022?
Yes, there were. So just to give some background on this, if employees request an exemption from vaccine requirements, employers must consider whether a reasonable accommodation needs to be made based on disability under the ADA and based on sincerely held religious beliefs and practices under Title VII or similar state laws. Now, before the pandemic, such requests were not that common because it just didn't come up prior to COVID, other than on occasion. So we didn't have a huge amount of case law on this, and employers didn't have a lot of experience in dealing with these kind of requests. But then COVID hit, and obviously things changed quite significantly with numerous requests for exemption from vaccine requirements being made. And as a result, cases got filed claiming discrimination. And employers that rejected these requests broadly or who didn't have adequate training or procedures for handling these claims, not surprisingly, ended up facing the brunt of this litigation. Now, while some of these claims were resolved in favor of employers, Many are still pending, and future claims could arise as well, given that COVID is still with us and vaccine mandates remain in place in the healthcare industry in general. So now the EEOC has come forward, the Equal Employment Opportunity Commission, with guidance for employers on how to address religious accommodation requests relating to vaccines, and has also provided a copy of its religious accommodation intake form as an example for employers. So the guidance discusses how employers should begin with the assumption that the religious belief is sincere, and also goes through steps that employers should take if they have an objective basis to test or challenge the religious belief. It also discusses how to evaluate whether an employer can make a legitimate claim that a requested accommodation poses an undue hardship. And again, while this guidance from the EEOC it's not necessarily the law as if it was issued in a court decision or in the statute, it does influence courts in most cases and can be used as a baseline for employers to review whether they're complying with legal requirements. And if employers follow this guidance, they will have a good argument against legal challenges to their accommodation practices. So, and we also recommend that employers take a look and review the EEOC's provided accommodation form and either adopt a similar version if they don't have one, or tailor it to their particular organization's practices.
And what about COVID testing guidance?
Okay, so for background on this, the existing law that we have does provide that mandatory medical tests in the workplace are generally subject to a job-related / business necessity type analysis under the ADA. During COVID, the EEOC generally upheld mandatory testing using this standard. Now, in 2022, the EEOC updated its guidance to indicate that an evaluation actually needs to be done on a case-by-case basis to determine whether COVID-19 testing satisfies the standard, and it also provided a multi-factor test that employers should use to do this. So the relevant factors, according to the EEOC, include the level of community transmission, vaccination status of employees, the types of jobs at issue, such as whether they come into contact with others in the job, or they're medically vulnerable individuals, and other factors. So at least per the EEOC guidance at this point, employers should not automatically assume that mandatory COVID testing will be upheld as a matter of course. And once again, the EEOC guidance is not legally binding, like we talked about, but it does influence courts, and it should be reviewed by healthcare employers. So the takeaway is really that it's best to review this guidance, go through the multi-factor analysis for your organization, and evaluate whether, if you have an existing mandatory testing policy, whether it looks like it's going to satisfy the factors. And this should all then be documented in a mandatory testing policy, or if you don't have one, you'll need to adopt one or update your existing policies accordingly.
And as I understand it, the EEOC has also recently taken action regarding compensation data. Can you tell us about that?
Yeah. So last July, a panel of the National Academies of Science, Engineering, and Medicine released a consensus study report evaluating the EEOC's first-time collection of pay data from certain private employers and federal contractors. EEOC collected this data based on 2018 and 2019 EEO-1 forms that these employers were required to submit. And based on the data, the EEOC asked the national academies to independently evaluate it and provide recommendations. So not surprisingly, the report confirms that federal pay data collection is a necessary tool to effectively identify and combat pay discrimination. It also found that collecting this data helps the EEOC prioritize investigations and its allocation of resources, identify systematic discrimination, and analyze various workplace pay gaps. Now, in analyzing the data, the National Academies report also found significant pay gaps based on race, sex, and ethnicity within Silicon Valley technology firms, which it noted were worthy of further investigation, and which also shows that certain industries could potentially be targeted for further scrutiny by the EEOC based on the report. The report recommends that the EEOC engage in broader data collection efforts, including seeking data from a larger group of employers, including professional employer organizations, or PEOs. Now, the EEOC has indicated that pay data collection on the EEO-1 report will return, but any future collections will be preceded by public notice, public hearing, and opportunity for input. Now, in the meantime, the EEOC is examining the report and is going to use it to approach any future pay data collection. We can expect further collection efforts in the near future from the EEOC, especially given the current composition of the EEOC under the Biden administration. So employers in all industries, but certainly in the healthcare sector, would be well advised to get out in front of this issue if they haven't done so already. One way you can do this is by conducting a pay equity audit or analysis of your practices, which we recommend be done with consultation of legal counsel in order to maintain the attorney-client privilege as necessary.
Spencer, turning to state law developments, can you talk about what's been happening in terms of state law regulations on healthcare staffing agencies?
Yes, absolutely. So during COVID, a lot of healthcare providers started relying heavily on healthcare staffing agencies to address increased demand for and decreased availability of nurses and other healthcare professionals. So as a result, this prompted increased regulation of the industry. Here at the state level, we're seeing a lot of that activity, and that occurred in 2022, including efforts to address anti-competitive activities by staffing agencies and defining the roles and responsibilities of staffing agencies in these relationships. So last year we saw laws enacted in Connecticut, Illinois, Iowa, Louisiana, Pennsylvania, and Oregon. Now these laws are all share some similarities and they have some differences, but at a high level, these states are generally paying more attention to these agencies, making them do things such as require them to register with the state, become licensed, pay fees, preventing them from engaging in certain anti-competitive activity in their contracts, such as non-competes or other fees that have to be paid by the clients, such as buyout fees or placement fees, and providing penalties for failure to comply. So employers in these states really need to be cognizant of these new laws and focus on how things have changed, consulting counsel as necessary so that they are up to date on these new changes. And we can certainly expect this trend to continue in the future as other states will most likely follow these models of the states that acted in 2022.
Okay, important to know. Thank you. What about changes in California? I understand that California was quite active last year in terms of healthcare industry legislation.
Yes, absolutely. So California's legislature was active on multiple fronts last year. So they passed a new law, AB 890, that gives nurse practitioners a pathway to working independently from direct physician supervision. And the law creates two new categories of nurse practitioners, or NPs. So the first category is called a 103 NP. And this is someone who works in a group setting with at least one physician and surgeon within the population focus of their national certification. So this is the first phase created under the new law, and it allows NPs to practice independently, consulting a physician as needed. An NP who wishes to practice without standardized procedures must first apply to the Board of Registered Nursing for special certification. Now, the second category created is called a 104 NP. And these individuals can work independently within the population focus for their national certification. And the law requires them to work as a 103 NP in good standing for 4,600 hours or 3 years before they're eligible to become a 104 NP. So under this phased-in approach, eligible 103 NPs will not be able to become fully independent until 2026 at the earliest. But once they get full practice authority, they can practice within the complete scope of their license without physician supervision. And the intent behind this law is to provide greater access to primary care and mental health treatment because California has a shortage of medical providers. Now, in addition, California simplified the criminal background check process for home care aides and caregivers in community care facilities. So existing law in California prohibits people with certain criminal convictions from working in caregiving facilities or registering as a home care aide unless they receive a criminal record clearance or criminal record exemption from the California Department of Social Services. And the problem with this, according to the legislature, is that this just takes many months and is often backlogged. So they've passed a new law, AB 1720, to create a simplified exemption process for individuals with old conviction records. And the hope is that this will help ease the shortage of caregivers. The state will still have the discretion to require that an individual otherwise eligible for a simplified exemption complete the standard exemption process. Okay, so finally we have SB 1334. Now this is a really important change as it extends existing meal and rest break requirements under California law for private sector employers to the public sector healthcare setting. So public health sector healthcare employees who provide or support direct patient care in a general acute care hospital, clinic, or public health setting, including the state, municipalities, and the UC regents, are now going to be subject to the same meal and rest break requirements that apply in the private sector. Specifically, this requires that public sector healthcare employers provide an unpaid 30-minute meal period to covered employees who work over 5 hours, with an additional unpaid 30-minute meal period for employees who work more than 10 hours in a shift. And as well, they have to provide rest periods based on the total hours worked daily for 10 minutes of rest period time for every 4 hours worked or major fraction thereof. And employers do have to pay a premium pay if they fail to comply with these requirements. This bill also exempts employees covered by a valid collective bargaining agreement, provided that it addresses meal and rest periods. Now, I just want to stress this is a very brief summary of the California meal and rest break requirements. The rules are quite complex, and healthcare employers that are providing these for the first time under this law really need to consult with counsel, because we do see a significant amount of litigation in this area.
Really quite a lot of activity in legislation in the healthcare industry in California. Thank you for that summary. Turning to New Jersey, I understand that New Jersey also has passed some pretty groundbreaking new law affecting mergers and acquisitions. Can you tell us a little bit about that?
Yes, absolutely. So New Jersey has a new law that now requires healthcare facilities and home care services that are undergoing a change in control to provide employment security to all non-managerial employees affected by the change. So change of control under this law means one of three things. First, it can be any form of disposition of all or substantially all of the assets. So, for example, an acquisition. Second, it can be any form of disposition of a controlling interest in the healthcare entity, such as a consolidation, a merger, or a reorganization. And third, it can be any event that causes the identity of the healthcare entity employer to change, such as a purchase, a sale, or a termination of a management contract. Now, any healthcare entity undergoing one of these types of change in control must guarantee continued employment to all affected eligible employees for at least 4 months at the same rate of pay, PTO, and benefits prior to the change of control. And at the end of the 4 months, the successor employer must offer employment to any eligible employee who performs satisfactorily during that period. The predecessor employer must provide at least 30 days notice of employees' rights under this law. And the law creates a private right of action for employees whose rights are violated under the law, which can include liquidated damages, or other remedies available for wage violations, as well as reinstatement and other forms of injunctive or equitable relief. So this is a significant change that New Jersey healthcare employers need to be aware of.
Yes, indeed. That is groundbreaking. And speaking of penalties, I heard that New Jersey's neighbor passed a new law with some penalties that employers should be aware of.
No, absolutely, yes. So New York has enacted a new penalties for healthcare employers that violate state law prohibiting mandatory overtime for nurses. So prior to this law, New York prohibited employers from requiring a nurse to work mandatory overtime, subject to 4 exceptions: healthcare disaster, a government-issued declaration of emergency, an emergency from the healthcare employer that satisfies certain requirements, and an ongoing medical or surgical procedure on which the nurse is actively engaged and whose presence is necessary to ensure the health and safety of the patient. New York's new law put some teeth into this prohibition, penalizing employers who violate these requirements, scaling from $1,000 for the first violation to $2,000 for the second, and $3,000 for the third, and each subsequent violation. So, in addition, the employer must pay the aggrieved employee an additional 15% of the overtime as damages.
Any other state laws of note that we should be aware of?
Yeah, there's a few others. So Delaware updated its requirements for physicians reporting mental or physical disabilities in an effort to destigmatize doctors from seeking professional help for these issues. Florida increased the minimum wage for workers of Medicaid providers, such as employees and independent contractors, to be at least $15 an hour. Maryland also implemented some new reporting requirements for residential service agencies receiving Medicaid reimbursement to increase transparency regarding the number of personal care aides classified as employees and independent contractors. Louisiana passed new requirements directed toward healthcare facilities regarding procedures for preventing violence in the workplace. And Arizona increased the flexibility for healthcare professionals to practice as any form of business entity existing in the state.
Well, that is a lot of important information, both from state level and federal guidance issued on this. Thank you so much for sharing your expertise on this subject matter with us. For those listeners who are interested, please check out the K&L Gates hub at klgates.com for access to the full alert on this subject matter and our other publications. If you have follow-up questions, please always feel free to reach out to Spencer or to me or other members of the firm's healthcare and labor and employment teams. We thank you for being with us today.
Thanks again for listening to this episode of Working Wise, recorded in collaboration with Triage. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. If you have any topics you would like to hear about on the next Working Wise podcast, please send them to workingwise@klgates.com.